All right, Mike, so Dua Lipa is suing Samsung for $15 million in damages. People are searching. They want to know why.
British pop superstar Dua Lipa has taken one of the world's biggest technology companies to court. The global music icon has filed the lawsuit against South Korean electronics giants Samsung.
$15 million. A lawsuit filed against one of the most powerful technology companies on the planet. And at the center of it, a single photograph placed on millions of TV boxes, sold in stores across America. Dua Lipa says she never gave permission. Samsung says it got assurances from someone. And somewhere in the middle of those two statements sits a mystery. Because the one person who actually gave that permission, nobody will say who they are. This case is about a lot more than a photo on a box. It's about how celebrity identities get bought, sold, and traded without the person ever knowing. It's about a corporation that was told to stop and didn't. And it's about a question that nobody in the room wants to answer out loud. Who signed off on this? And why is Samsung protecting them? 10 hidden details. By the end, you'll have the full picture. Subscribe and hit the bell right now. I have a follow-up video this week covering what this lawsuit could mean for every celebrity endorsement deal in America, and what Dua's silence on social media is actually signaling. Subscribers get it first. Let's go. 10. The photo was taken backstage, and Dua Lipa owned every right to it.
We know who owns the photo being used in Samsung's product marketing.
Yeah, so according to this lawsuit, Gio, Dua Lipa and her team own the rights, title, and interest in this particular image. The photo in question was taken about 2 years ago at Austin City Limits, which is a music festival.
Let's start with the image itself, because this detail matters more than people realize. The photograph at the center of this lawsuit is officially titled Dua Lipa Backstage at Austin City Limits, 2024. Lipa owns the copyright to it, registered with the US Copyright Office under copyright registration number 5/2479685. This is not a paparazzi shot taken from a public street. This is not a promotional image licensed to a record label. This is a photograph that Dua Lipa owns, personally, legally, entirely. Every right, every use, every decision about where it appears and who profits from it. Samsung placed that photograph on the cardboard packaging of its Crystal UHD televisions and sold those boxes in retail stores and online beginning in 2025 without Lipa's knowledge or permission. So before we even get to the lawsuit, the negotiation, the lawyers, or the $15 million, the basic fact is this: Samsung put someone else's property on its product and sold it. And the person it belonged to had no idea. 9. She found out the way everyone else did, by seeing it. Here is the detail that tells you everything about how seriously Samsung took this situation initially. Lipa discovered the unauthorized use of the image in June 2025 and immediately sent a cease and desist demand to Samsung. Not through a formal notification, not through a licensing dispute. She found out her face was on Samsung TV boxes, being sold across America, the same way a regular person finds out. She saw it, or someone close to her did. Think about what that means. One of the most commercially visible artists on the planet, with a team of managers, lawyers, and brand partners managing her image across dozens of global deals, and nobody at Samsung thought to contact her. Not before using the image. Not while the boxes were being manufactured. Not when the TVs were hitting shelves. The first communication between Dua Lipa and Samsung about this image was a cease and desist letter. That is where this story starts, and it gets worse from there. 8. Samsung didn't just ignore her. It kept selling.
To see how that works out, or if Samsung paid like Getty Images to use that, like what does that mean? But definitely protective of her image.
Yeah, and a lot of performers, musicians, they're doing that right now. They're quick to sue for sure for their likeness.
So Dua Lipa sends a cease and desist in June 2025. Clear, legal, formal. Remove my image from your product. Her lawyers wrote, Samsung has repeatedly refused to do so, and instead has continued to willfully, intentionally, and purposefully infringe on Ms. Lipa's rights for its financial benefit, maintaining for sale the infringing products bearing the DL image. One demand, ignored. Another demand, ignored. Month after month, through the rest of 2025 and into 2026, the boxes stayed on shelves. The TVs kept selling. Dua Lipa's face kept moving product for a company she had never agreed to work with. Her lawyers say she first became aware of the problem in June 2025 and immediately demanded that Samsung remove her from the packaging. But almost a year later, they said there had been no progress and that they had essentially been forced to file a lawsuit to deal with it. A year. 12 months of requests, demands, and silence from a company worth hundreds of billions of dollars, responding to a woman who simply wanted her own face off their packaging. The lawsuit wasn't the first option. It was the last one. 7. Her lawyers called Samsung's behavior dismissive and callous. That phrase was chosen very carefully.
To comply with her cease and desist. So does she have a case here?
I think she's got a pretty good case. First of all, the fact that they were aware of it and didn't do anything about it shows they have intent. Shows that there's some type of willful infringement, willful violation, and that can trigger additional damages.
Legal language is precise by design. When Dua Lipa's attorneys wrote that Samsung's response was dismissive and callous, they weren't venting on her behalf. They were building a case. In intellectual property litigation, demonstrating that a defendant knowingly and willfully continued infringing after being put on notice is the difference between standard damages and enhanced damages. The more times you ask someone to stop, and the more times they refuse, the more intentional the infringement looks, and the bigger the number a judge or jury can award. Her attorneys wrote, Samsung's arrogance in refusing to stop its infringement confirms its conscious disregard of Ms. Lipa's intellectual property and personal identity rights. Every ignored demand letter. Every month, the boxes stayed in stores. Every TV sold with her face on it after she said, stop. All of it is now evidence. Samsung didn't just use her image without permission. It had the chance to fix it quietly. It chose not to. That choice is now worth $15 million. 6. Real people bought Samsung TVs. Specifically because they thought Dua Lipa endorsed them.
And they're making money off it. That's a big problem for them. And she has a good case.
Well, and we see that comment from a fan right there. I wasn't even planning on buying a TV, but I saw the box, so I decided to get it. And that's probably what her team is actually saying, like, hey, this is selling stuff. So does Samsung have a defense here?
This is the detail that makes the Lanham Act claim genuinely dangerous for Samsung. The lawsuit quotes comments on X, formerly known as Twitter, suggesting that at least some customers were moved to purchase Samsung TVs by the apparent endorsement. I wasn't even planning on buying a TV, but I saw the box, so I decided to get it, wrote one commenter, quoted in the complaint. I'd get that TV just because Dua Lipa is on it, wrote another. That's how obsessed I am. That's how much I love her. Dua Lipa's legal team didn't need to speculate about consumer confusion. The consumers themselves provided it, publicly, on social media, in their own words, before the lawsuit was even filed. Another wrote that if you need to sell something, just put a picture of Dua Lipa on it. Samsung didn't just use an image it wasn't entitled to. It used an image so powerful that real people changed purchasing decisions because of it. That is the commercial value Dua Lipa has built, and Samsung collected it without paying a cent. Quick stop, subscribe, and hit the bell right now if you haven't already. 5. Samsung blamed someone else and won't say who that someone is.
So Samsung is largely gonna challenge it, either with ownership of that photograph, possibly that maybe it's de minimis usage, things like that. You know, fair use is often a defense, but I don't think it's gonna apply here. They're certainly gonna try to challenge the liability. I think it's gonna come down to more to damages. How much do they owe? And that's where the fight's gonna be. They're gonna say, hey, we didn't make that much money off of it.
When the story broke globally, Samsung released a statement, and instead of an apology, it pointed a finger. Samsung says that Lipa's image was used in 2025 to reflect the content of our third-party partners that is available on Samsung TVs. The company further added that the image was originally provided by a content partner for our free streaming service, Samsung TV Plus. Samsung further added that it used the image after receiving explicit assurance from the partner that the permission had been secured from the rights holder, including for retail boxes. A content partner who gave explicit assurance, who told Samsung that Dua Lipa had agreed to this. Here is the problem with that explanation. It does not explain the alleged long delay in solving it. If Samsung genuinely believed the image was licensed, why, after receiving a cease and desist from Dua Lipa's own legal team, did it take almost a year to act? You have the artist herself, through lawyers, telling you the permission doesn't exist. At that point, the content partner's assurance is irrelevant. And that content partner? Still unnamed, still unidentified, still protected by Samsung's statement. Who gave Samsung permission to use Dua Lipa's face? That question remains unanswered. And the longer it stays unanswered, the more interesting it becomes. 4. She is one of the most selective brand partners in the industry. Samsung knew that.
The lawsuit includes the claims of copyright infringement and the right of publicity violations. So how does copyright and right of publicity protect Dua Lipa in this case?
So everybody has a right to their name, image, and likeness and how it's commercially exploited. Everybody has a value to that. And especially celebrities and singers like Dua Lipa. Her brand and her name and her image are worth a lot of money.
This is not a celebrity who says yes to everything. Over the course of her career, Lipa has partnered with several major brands, serving as a global ambassador for Puma, YSL Beauty, Bivalgari, and Nespresso, co-creating a fashion line with Donatella Versace, collaborating with Yves Saint Laurent on its Libre perfume, and teaming with Porsche, Apple, Chanel, Tiffany, and Coty, and several other luxury and fashion houses. She also recently starred in a campaign promoting the 2026 Winter Olympics in Milan. The suit states that Lipa has cultivated a premium brand and is highly selective in making product endorsements. Every brand on that list is a multi-step negotiation, a carefully considered deal, a contract reviewed by lawyers on both sides. Dua Lipa does not attach her name to products casually, and the brands she works with pay accordingly because of that selectivity. Samsung is a global electronics company. It has a legal team. It has brand partnerships executives. It knows exactly how celebrity endorsement deals work, which means using an image of this artist on this scale, on a mass-market consumer product, without a signed agreement, is not an oversight. It is a decision someone made. And that decision is now the subject of a federal lawsuit. 4 separate legal claims. Each one a different kind of problem for Samsung. Most people are covering this as a single lawsuit. It is not. It is 4 separate legal arguments stacked on top of each other, and each one represents a different way Samsung is exposed. The complaint alleges a copyright violation, a violation of the California Right of Publicity statute, a federal Lanham Act claim, and trademark claims. Copyright infringement, because Lipa owns the photo and nobody licensed it. Right of publicity, because California law specifically protects individuals from having their likeness commercially exploited without consent, regardless of who took the photo. The Lanham Act, because Samsung's packaging created a false impression of endorsement that misled consumers. And trademark infringement, because Dua Lipa's identity as a brand carries commercial weight that Samsung benefited from without authorization. Both Samsung Electronics America, Inc., and its South Korean parent company, Samsung Electronics Company, are named in the lawsuit. This isn't a dispute with one division of a corporation. This goes all the way to the top of one of the most powerful companies in the world. And Dua Lipa's legal team filed in federal court in California, one of the most plaintiff-friendly jurisdictions in the United States, for exactly this type of case. 2. The unnamed content partner is the key to this entire case, and nobody is talking. Let's go back to the most important unanswered question in this lawsuit. Samsung says a content partner provided the image and confirmed the rights were secured. That content partner has not been named publicly. They have not issued a statement. They have not appeared in any court filing that has been made public. They are, for now, entirely invisible. But here is why that invisibility matters. If Samsung's defense is, "We were told it was licensed," then at some point, a judge is going to ask, licensed by whom? Through what agreement? Where is the documentation? Who at that content partner authorized this? Who communicated that authorization to Samsung? Lipa's legal team argued that Samsung has profited and continues to profit immensely from the use of Lipa's image. On information and belief, a significant portion of the televisions sold by Samsung in the United States in 2025 and to date bear the DL image on their boxes, the use of which has contributed in no insignificant way to the enormous revenue generated for Samsung by the sales of these televisions. The unnamed content partner is the person or company that either made an honest mistake or lied to Samsung, or was themselves deceived by someone further up the chain. Until that name surfaces, the full picture of this case cannot be drawn. And the longer they stay unnamed, the worse this looks for everyone involved. 1. This case could change how every celebrity image in America is used forever. And here is the detail nobody is talking about loudly enough. If this case proceeds to trial, it could set a significant precedent around the commercial use of celebrity images on product packaging. Right now, the rules around celebrity images in digital supply chains, where a streaming service licenses content, passes images to a platform, which passes them to a hardware partner, which puts them on physical packaging, are genuinely unclear. There is no established legal standard for how far down that chain a celebrity's consent travels. Samsung is arguing it relied on assurances. Dua Lipa is arguing those assurances were never hers to give. Whoever wins this argument in court doesn't just win $15 million. They shape the legal framework that governs how every brand, platform, and electronics company in America can use a celebrity's face going forward. That is why Samsung hasn't settled quietly. That is why this went to federal court. And that is why the entertainment industry, the tech industry, and every brand partnership lawyer in the country is watching this case extremely closely. Dua Lipa's face on a TV box is the visible part. The legal question underneath it could rewrite the rules for everyone. So here is where we stand. A photograph taken backstage at a music festival, used on millions of TV boxes sold across America without a signed agreement. Almost a year of ignored demands. A federal lawsuit with 4 separate legal claims against one of the most powerful corporations on the planet. And somewhere in the middle of all of it, an unnamed content partner, still silent, still protected, still holding the answer to the question that started all of this. Dua Lipa didn't ask for a fight. She asked for her own face back. Samsung said no, for 11 months. Now a federal judge gets to decide what that no was worth. Subscribe right now, because my follow-up video this week goes deep into what the discovery phase of this lawsuit is going to reveal. Why the unnamed content partner is the most important figure in this whole story. And what happens if Dua Lipa wins. That video goes to subscribers before it hits anyone else's feed. Hit subscribe. Hit the bell. Drop a comment below. Do you think Samsung genuinely didn't know, or did someone make a calculated decision and hope she wouldn't notice? I want to know what you think. I read every single one. See you in the next one.